Hey AP Gov people, we got a video for you today, number 35, the Judicial Branch, a brief intro. So we're going to break down some basics of the Judicial Branch. Some important terms you should know. Plaintiff, this is a person or a group, it could be, that charge the defendant in either a civil or a criminal case. Now, a famous plaintiff that you are aware of is William Marbury. Now, he charged the defendant, James Madison, in the famous court case Marbury versus Madison. Civil law is another term you should be familiar with. This is a dispute between two people or groups. It could be a divorce, it could be a child custody, it could be I'm suing you for a car accident, anything like that. And criminal law is when the government is the plaintiff and charges someone with a crime. In most cases, whether they're civil or criminal, never, ever go to trial. A very small percentage actually go to trial. Most of them are settled or plea bargain. Okay, class action suits. This is when one group representing many people sues another. And a famous recent example is former NFL players and concussions. This lawsuit from a couple years ago, led by many former players, including this guy, Super Bowl winning quarterback Jim McMahon of the Chicago Bears, 1985, the Super Bowl Shuffle. Look up the video, it's great. Amicus curiae, this is Latin for friends of the court. And what this allows is for interest groups, the government, corporations, etc., pretty much anybody, to write the Supreme Court about a court case. In this letter, it would describe to the court how the decision would affect them. So a lot of very popular court cases that go to the Supreme Court are flooded with amicus curiae briefs. And this provides key information not included in the case. Maybe it's not included in testimony or something to that effect. So basic facts. When we're talking about the judicial branch, it's Article 3 of the Constitution, and this requires a Supreme Court and inferior court. Judges hold their offices during what is known as good behavior, it states in there. And this is important because Samuel Chase, he was impeached for pretty much his political beliefs, not how he was as a judge, and this set the precedent that even though he was impeached, he was not removed from office. So good behavior pretty much requires you to break the law in order to be removed. The Judiciary Act of 1789, definitely know this bad boy. This allowed Congress to create lower federal courts and set the Supreme Court with 6 justices, 5 associate justices, and 1 chief justice. You know that number is now increased to 9 today. It was during Reconstruction. President nominates Supreme Court justices, but they must be approved by the Senate. That's checks and balances and interaction between different branches of government. And throughout most of history, justices have been white males. The first African-American male was Thurgood Marshall in 1967, and the first female justice was Sandra Day O'Connor in 1981. And justices serve for life, and the idea is that they won't be influenced by public opinion or partisan politics. I want you to star circle, underline this. Know this, very, very important. Be able to not only identify, but explain why justices serve for life. So they're insulated from partisan politics or public opinion. So they can make a right choice, although it may be unpopular, but the correct legal choice and not have to worry about being reelected. 4 test tips, multiple choice. No amicus curiae, no interactions with the Senate, and the idea of approving Supreme Court nominees and nominations of judges. Free response, interactions with the Senate, approval again. And why does the Supreme Court hold office for life? All right, guys, look forward to see you back here for video number 36, the structure of the judicial system. Thank you very much for watching. Best of luck in May, and have a good day.